Good afternoon, everyone. It's very cold. I'm looking outside my window. Rainy. No, it's actually not rainy, but it's been raining all day. I think JB will maybe is the one who hasn't even noticed if it has rained today or not in Kampala. I'm not sure how it is in Kenya. I'm told the rains are actually an East African thing, so maybe even David's is a little cold. But it's a pleasure to speak to you this afternoon. My name is Kenneth Muhanji. I'm the chair of the Technology, Media and Telecommunications Committee or Cluster of East Africa Law Society. And as per our series, we are this afternoon looking at telecoms. We had a panel about a month ago where we looked at anti-competition within the telecommunications sector. And today we are breaking down the telecom law practice further by looking at mergers and acquisitions, and also looking at emerging trends in the telecom space. And so I will start by apologizing. We had cancellations from two of our panelists, Julia Kilala and Sharon Mazimaka, who were not able to join at the last minute this is something that we really apologize. And so we will be this afternoon speaking with David and John. Don't panic when you see all guys on the panel. It's because of that those unfortunate cancellations that we had, but that was also really out of their control. And so I'm not sure if David Sigano, the CEO of East Africa Law Society, is online, and if you'd like to just introduce the webinar, or should we just get right to introducing the bios of the panelists? David or Gabriel, are you online? Okay, so I think we can move ahead. I'll say that since I'm chairing the committee, I will speak on behalf of East Africa Law Society by saying again, you're welcome to our speakers. And this afternoon, we hope to have a very interesting discussion, as I said, around emerging trends in telecoms, but particularly around mergers and acquisitions. And our two panelists this afternoon are John Bosco Sempija, who is the country lead at Telecom Uganda. John is an enrolled advocate of the High Court of Uganda with over 12 years of experience working in the telecom sector. He has an LLM from the University of London, an LLB from Makerere University, and a diploma in legal practice from the Law Development Center. John has held several senior managerial positions with reputable national telecom operators, including MTN, Uganda, MTN, Dubai, Roshan, Smart East Africa, and currently Telecom, where he's a country lead for Uganda. He has also worked across several countries like Uganda, the UAE, Afghanistan, Burundi, and Tanzania. He has advised on and participated in various and often pioneering mergers and acquisition transactions across the region, including the formulation of the first tower company in Uganda under a sell and leaseback model. And we shall be asking John to just help us break that down, setting up of an IT hub, and acquisitions by share purchase, acquisitions by transfer of license, disposal of assets, and the like. John, we are very privileged to have you on our panel. You're welcome.
Thank you, and good afternoon, everyone.
We also have David Lekerai. He's a partner and head of the corporate practice at DLA Piper Africa in Kenya. His areas of practice include private equity, mergers and acquisition, corporate law, commercial law, structured trade finance, including Islamic finance, corporate restructuring, as well as capital markets. David has been involved in many local and cross-border transactions involving private equity investments and divestments, corporate reorganizations, and joint venture capital raising, including by way of equity, debt, and convertible debt instruments. David, it's such a pleasure to have you on this afternoon. You're welcome.
Thank you very much, Ken. Good afternoon, everyone.
Okay.
Looking forward to an interactive session.
Thank you. And so I think we can get right to it, unless Gabriel, who I see has joined, would you like us to hear your voice, Gabriel? Do you want to say hello?
Thank you so much, our esteemed panelists. We, on behalf of the East Africa Law Society, would like to thank you for accepting to take part in this webinar, and we hope to learn and share experiences as
Gabriel, I think your line is breaking. We can barely hear you. So we can continue as you try and fix your connection. So panelists, David and John, this afternoon our audience is lawyers from East Africa Law Society. And as you can see, I don't know if you can see how many have joined, but we have quite a number of participants. So our job this afternoon is try to break down this telecom practice thing even further. And that's why we've called seasoned telecom law practitioners to take us through what is involved in the telecom law practice, specifically around the topic of mergers and acquisition, and also any other emerging trends that you feel you can be able to share with the members. Our goal at the end of this session is to see if we can be able to share this knowledge with the rest of the membership to perhaps interest other practitioners to practice telecom law. But outside of that, to also understand, because we specifically from you, JB, as someone who's worked perhaps in private practice and then has worked as in-house counsel as well, and now you're a country lead for an entity that's working in the telecom space. What advice can you give to lawyers that would want to represent a company like Telecom to be able to sharpen their practice? And David, as well, from your experience working in private practice, what can you share in regards to organizing a telecom practice? So these are really the things that we are going to look at today. So maybe to start, since we are looking at the topic of mergers and acquisitions, I'll start with David. David, could you just introduce to us what is meant by a merger and acquisition specifically within the telecom space?
Okay, thank you very much, Ken. And again, it's really a pleasure to get the opportunity to share ideas with professional colleagues. Quite a number of the practitioners may or may have not been involved in the area of telecoms, and particularly with respect to M&A. So as you go on, I'm sure you will, quite a number will find this topic and the discussion fairly familiar. And at some point, of course, we will welcome your remarks or any thoughts that you may have that are either agree or align with some of the comments we'll be making, or some which, and it will be obviously welcome, any thoughts that may not necessarily be aligned with that. Now, to your question, and so the meaning of merger, and the thing is, whenever we encounter the discussion merger, one then will have to figure out exactly in what context are you addressing that particular subject. And as far as I'm concerned, or at least based on the usual or the more regular interaction with that particular term, it could have two meanings. The classic meaning of what a merger is the amalgamation or combination, or if you like, fusion of two or more legal entities or business or operations into one business or operation. So you have a business or a legal entity, you have another one, two or three or more, and then you bring them together. And that is really the classic meaning of what a merger is under corporate law. And I'm sure as you go along, we'll probably discuss exactly how that can happen. But apart from that, the second meaning then of merger, which is what may bring some confusion from time to time, is the definition of merger under competition law. And this is something that arises with respect to both regional and municipal law. Quite a number of the East African countries have their own municipal competition law. And I understand Uganda also probably recently adopted one. For a long time they didn't. But apart from that, we then have regional, including the commercial competition regulations, which is the more regular. But the meaning then of a merger within that framework is a transaction that involves the acquisition or the change of control of a business or part of a business or asset of a business in any manner. And all these terminologies have some meaning or some connotation in one way or another when someone goes further to dissect exactly what you mean by part of a business or an asset of a business. With respect to, say, an asset of a business, it's not necessarily acquisition of any asset, but maybe acquisition of a group of assets that are identifiable, and once acquired by the person acquiring them, that person can then proceed to trade with them without changing anything whatsoever. But before I stop and just allow Ken or anyone else to join in and just seek any clarification if necessary, I've mentioned the term control within the meaning of competition law. Now, we then need to understand exactly what we mean by control. So, and there are a number of parameters or elements that would constitute control. The most obvious one is when someone or a group of individuals or persons acting together acquire more than 50% of the shares or units in an economic entity. It doesn't necessarily need to be shares in a company, it could be any other legal entity. The second one is acquisition of 50% of the voting rights. So one may ask, what exactly is the difference between those two? And there could be some difference depending on how the transaction is structured. The third one is then the ability to appoint majority of the directors to the board of that legal entity, or whichever decision, executive decision-making body of an economic entity. And the last one, and at some point we'll probably be happy to discuss this a lot more, is what is called acquisition of material or decisive influence. Maybe I can pause there, Ken.
Oh, David, you're really taking us to school. Maybe actually before we move on to JB, are there any specific laws, David, that govern mergers and acquisitions, and not only in Kenya, but in the region? Because I know definitely with the frameworks that we have, we'll definitely share legislation. So are there any specific laws that would look at M&As?
Yes, absolutely. And maybe before I go into that, sorry, I think I didn't discuss the issue of acquisition. So I just address the aspect of merger, but then there is the element of acquisition. Now, acquisition is obviously, and some of these things are really more generic than anything else, or just used in the course of transaction. But acquisition could in fact amount to a merger or not. But basically it means obtaining a stake of whatever measure or size in a legal entity or a business. So if, say, which then of course would give you either ownership or an economic interest in that business. So if, say, for example, you acquire a certain aspect or right to participate in the economic returns of an entity without necessarily acquiring ownership in that, that could actually amount to an acquisition. But most of the acquisition obviously are reflected by way of acquisition of ownership through either shares or any other ownership interest in a legal entity. And as I said, acquisition could amount to a merger within the meaning of competition law, if of course it has the element of change of control, or generally under corporate law, if then it brings together two entities, it combines or amalgamates two entities. Now to your question, Ken, I'm sure the list is non-exhaustive, and I'm going to mention a couple of them, but there are quite a number of laws that cuts across the practice of M&A in the various countries within the region. And the first one that I would like to highlight is the law of contract. The reason that's why that is important is because essentially we are talking of a commercial agreement here, a commercial deal. So that needs to be properly reflected based on the law of contract, and all the traditional element of what must be present for a contract to be deemed to exist should be present or should be identified in that particular transaction. Now, one would ask, what is the law of contract? That could either be the law of contract as set out by statute. I believe all the various countries within the region have specific statutes that deal with the law. But in addition to that, we also apply common law in some of the jurisdictions. I believe Kenya, Uganda, and if I'm not wrong, Tanzania also does apply common law. Rwanda, to my understanding, and we've done a couple of transactions with colleagues in Rwanda, do not necessarily apply common law, but again, the principles are really not dissimilar. So the things like, and one of the critical item or elements that I would like to highlight is that aspect of intention to create legal relations, which would have to be properly reflected in the drafting. Quickly then, so as not to take too much time, the other piece of legislation or law that I would like to highlight is a company law. In Kenya, we call it the Companies Act. I know different jurisdictions have different terms to it. The Companies Law, the Companies Act, and the Articles of Association of the corporate entity. And the reason for that, obviously, transfer of shares, typically most of the economic units that are transferred in or dealt with in an M&A shares, those would be governed in accordance with the Companies Act, which then probably defers it to the procedure that is outlined in the Articles of Association. If you are dealing with a limited liability partnership, or a partnership for that matter, then of course you then also have to apply that law. In the telecommunications sector, which is really the area of interest today, you then have to apply and consider the telecommunications law and the regulations for a number of reasons, all the way from due diligence, and we'll see some of the things that would be critical in as far as telecommunications law is concerned, but that's a specific legislation that would also be relevant. We've already mentioned competition law. One will have to consider whether it's COMESA or municipal. In COMESA, you then need to consider whether it's a one-stop shop, or you will still also need to go to the national law competition authority, national competition authorities. But the good thing is these days there seems to be a framework where quite a number of the member states within the COMESA have removed the need to then do a double filing. Quickly, let me mention others without elaborating them, without going further into them because of time, is what one may call the transfer of business laws. So in Kenya, we have a transfer of businesses act, and this is more applicable when you are dealing with transfer of assets. You may want to make certain notices to ensure that you do not, by operation of law, carry the liability as well. Maybe your interest was to acquire the business and the assets and maybe the employees, but you never intended to acquire certain liabilities. That transfer of business law, and I believe Tanzania as well do have that, with something that, that will be applicable. And then I will also just mention the employment law in the context of transfer of business. Tax laws would be relevant, particularly for filing formalities. If an entity is listed on a security exchange, be it the Nairobi Security Exchange, Dar es Salaam Security Exchange, or USC, or even the Rwanda Security Exchange, then the capital market statutes and regulations, which are fairly, I won't call them complex, fairly elaborate or comprehensive, is something that would be applicable. Last but not least, I would also like to highlight, particularly in the context of cross-border transaction, foreign control laws. It's not fairly common in the East African countries, Kenya, Uganda, Tanzania, Rwanda, Burundi, and the others, although I may want to confirm the position with respect to Burundi, but this is something that we have encountered in some of the Southern African countries, particularly Malawi and South Africa. So for you, you then need to be aware of, or know, or at least do research to figure out, is this relevant and how does it affect your transaction? So there are quite a number, but just by way of highlighting a few, those are the things, those are the ones that I believe are very critical.
Very good, David. And actually now perhaps moving on to JB. You know, from your introduction, we can see that you do have experience with practicing in Tanzania and in Burundi. In terms of those laws that David has mentioned, do you think that there is, there's a big divergence in regards to, are there any others that you'd like to add a supplement, but is also there a big divergence in regards to the procedure or the restrictions regarding mergers and acquisitions within the telecom space?
Thank you, Kenneth. I think for Tanzania, it's not so much because, you know, they follow more of the common law practices and they apply actually commercial regulations from the anti-competition side. But for Burundi, there is a slight difference because they are more francophone. So, but the basics remain that, you know, you will seek regulatory approvals and you will ensure that, you know, there is what David called a contract, basically that the entities agree to do whatever they have agreed to be done. And that if that action needs any approval, because the telecom sector is quite controlled, obviously because it is more of a public good, and you are serving customers who are impacted by such transactions. And there is also need to make sure that there is competitiveness in the sector, which then drives value to the customers. So hence why you see a lot of stringent regulations, even in just merely the transactions.
You are muted, Ken.
Yeah, I was. Thank you for that, David. I was saying, JB, thank you for that clarity. Maybe just for the audience that is listening, we're going to make this session a little bit more interactive. So I've actually asked East Africa Law Society, to the Secretariat of the Online, if there's anyone as we're speaking, if there's a point you'd like to highlight, we can ask East Africa Law Society to add you, and then you can be able to speak, you can have your video on and speak, and then be able to move you after. So that can be after we've, you know, cut through this first basic, first understand the topic today. And then either this can be during the question and answer approach or even before. So we're going to make this section a lot more interactive. If you also have any questions as we're moving along, please do put them in the chat, and this will then be seen by the panelists, and then they will be able to answer them in real time, so that we don't even have to wait for the question and answer section. And so maybe JB, before David, because I'm seeing there's already a question for David, but before that, could you help take us through the different models for mergers and acquisitions?
Thank you, Ken. I think in addition to what David pointed out, while there can be an acquisition which leads to a merger, there can also be separations actually, where, you know, businesses are separated and delinked from one another. And that's also a form of an M&A transaction that you will find happening in this space. But for the ways through which these M&As are conducted is more often defined by the driver of the transaction. And this is more of what has caused the transaction. Is it a business efficiency where, you know, the entity seeks to create some optimization in its business operations? So here you're looking at, you know, basic things like outsourcing and separation of, let's say, the consumer business and the enterprise business. You've seen where you're outsourcing your finance operations or procurement or IT services. So those factors sort of determine how you do the transaction and the way through which you carry out or structure the transaction, so to speak. The other driver is really where the transaction is guided by regulatory changes or compliance requirements. You've seen the recent drive to separate mobile money entities from the pure telco services. This has happened across the ESC. We have also seen regulatory changes in Uganda where they have created regional licenses, and those obligations then required a reorganization of businesses within the sector. We also saw some listing requirements, which drove another set of transactions under the M&A category, some of which in fact forced exits. You know, the case of Smile, the case of AfriCell, the case of Smart in Uganda. So all those are drivers, and those then determine how you structure your transaction for efficiency and to achieve the objective for which you are doing the transactions. But again, we can also see just pure exits due to business failure, or where corporations have changed strategy. They don't wish to invest in the specified countries anymore. All that business has just become tough. So this is, you know, Worried exited, Orange exited, and things like that. But generally, based on those, you will then pick a way on how to structure your transaction. Often you can do, you know, share purchases where one entity buys the shares in the other. Now that can also lead to a subsequent or a continuous transaction where you can keep that entity operating as an independent one, or then you can integrate it into the acquirer's business. For example, the case that happened when Airtel acquired Worried, you know, you then acquire the company and integrate it into your business, your existing business. The same thing that happened when in the TowerCo space, ATC acquired Eaton. They were completely absorbed. So you start with one process and then you end up into another. You also have direct integrations, as we have looked at, basically considered from a going concern point of view. There are also some tax elements and efficiencies that you look at. For example, when you want to utilize, you know, some tax losses and things like that. So the ways are more hinged on the advantages and the objective for which the transaction is conducted. But we also have another form where you will simply form a new company and then you transfer the assets of from the existing entity into the new co. Basically, you are asset stripping. And this is what happened, you know, with the mobile money space. New companies were created fully. This is the same that happened with, for example, the MTN, ATC, TowerCo model. And it also happens in the wholesale environment, that you can separate your wholesale business into a completely new entity. It's what is happening with, you know, you've heard about MTN Global Connect. It's purely catering for the wholesale customers. We also have seen similar things with, for example, British Telecom. They have a BT Enterprise that is a separate entity from the BT consumer business. I also had a chance to advise, you know, Telecom Kenya when they were considering going that route. So it all depends on what objective do you want to achieve with the transaction. Then you design and choose an effective way. Of course, you are looking at business considerations as well as operational considerations. Lastly, where there is a pure exit, you will then look at disposing the assets directly. And this is, for example, what happened when Telecom Uganda bought the assets of AfriCell. Africell was exiting, and they just stripped out one single asset and said, look, go with it. I know another number of operators who also sold out their assets when the license regime changed from national to regional in Uganda, where if you had infrastructure in a different region, which you did not prefer to operate in, then you sold off that. So those are all ways on how, to skin the cat, but with the main cause and the rationale for why you want to do the transaction.
JB, thank you. I think there was a question actually, but which thankfully you've already answered from an anonymous attendee saying are forced exits a form of merger and acquisition. But I think this is something that you're already explaining, that especially if you have an acquisition, looking at it from the acquisition side, you will have most of these acquisitions, especially in the region, you find that they will happen usually for entities that are exiting, where their assets are stripped, and another entity will then be able to acquire these assets. So this definitely forms a part of the mergers and acquisition space that we're talking about today. But JB, I don't know whether there's anything else you can be able to explain, or from your experience specifically, as you mentioned, let's say from Telecom buying the assets of Africell. Is this what would a lawyer have to look out for in that regard, especially if you're trying to strip an entity? And perhaps this is a question that you'll answer, and then David, you can just store it. In Uganda, we say Simba Wakati, you can put a stick there, but around intellectual property as well, how important is the entity's brand? If you're acquiring an entity that is exiting, for example, if you're acquiring, let's say, software from that particular company that you're then going to incorporate within your model, is the intellectual property something that you're keen on looking at? Maybe you can answer it from that perspective in regards to asset stripping, and then David can answer that from the point of mergers as to how big a role intellectual property plays in regards to perhaps if you have a dominant brand, how important is the agreement or the clauses that speak to that? How important are they when you're concluding those transactions? But first, JB.
Thank you, Ken. I think, yes, it is important that you look at some of the transferring assets. Some of the assets come with licenses, and those IP licenses are often, either owned by the selling entity or by third parties. And depending on how you have structured your transaction, you will either seek for consent from the IP holder. That is where you are, having third-party providers like, if you have Huawei or ZTE running the installations, then you seek for their consent when you're doing the acquisitions. And where there is any internal IP that is developed by the selling entity, then you would as well agree on whether you are taking that over or not. It's all part of the scope of the agreement that the parties reach, depending on if I am going to buy the asset and integrate it into my existing operations, where I have similar softwares and IPs, then I don't need to take over certain IP. So it all depends on how you have structured and what the business need is. And very often we see that when you are, there is an exit of a telco, except where you have instances of exits due to independent business failure, some of these assets are then sold off and acquired to be operated by another entity. So it's not that all exits are as pure exits as they can be. But in the telco space, because these assets can be operated independently, you find that any business failure exit can actually result into an M&A through a disposal process.
Okay, JB, thank you for that. David, before you come on, let's have a comment from Hughes Chinning. Hughes, would you like to share something, please? Hughes, are you there? I think you can unmute if you're speaking. Your hand was up. Okay, I think he's not listening to us at the moment. David, you could please go ahead and just speak to the question I'd asked about intellectual property. But then also, if you could, there's a question in the chat since you were talking about COMESA. I think you're the one who had mentioned about the regulations, but the question was actually still going to JB as well. Do the COMESA regulations apply to Tanzania? And then also Burundi. There are questions from, these are questions from Emmanuel from Burundi. But let's first start with those two, David.
Okay, thank you, Ken. So let me, as I address that question on IP, and of course, I must confess that I'm not an IP lawyer, I'm not an expert at all, but of course, we have colleagues who help us in that area. Can you allow me to just quickly mention something on what John discussed earlier on the form of mergers, the models of mergers, transaction. Sure. And I agree 100% with all the issues that John has highlighted. There's only one that I wanted to mention, and I don't think it's applicable to all the jurisdictions. I've only seen it in this region so far in Rwanda, but I've seen it in other jurisdictions outside Africa. The framework which allows a direct combination of two or more entities resulting in what one may call a surviving entity. And all the other entities immediately die, if you like, or cease to exist by operation of law. So once you go through the formalities, you then, of course, at the end of the day, at the end of it all, obtain what is called a certificate of merger from the Registrar General in Rwanda. And that then, of course, indicates which entity. Of course, there are all manner of things that needs to be done before that, including valuation, because to be able to combine two entities, the aspect of valuation, so as to determine the amount or the number of shares that the different shareholders across the entities would end up with is critical. In addition to the various formalities such as shareholders resolution, typically special resolution from both combining or the different combining entities. But at the end of it all, you get a certificate of merger, and that basically amounts to one entity ceasing to exist, and the other entity by operation of law taking the assets, the liabilities, the employees, and everything in the two entities. That's something that we encountered when we did the KCB transaction, which is in the public domain. After acquisition, they merged the subsidiary they had acquired with the KCB bank they had. It's applicable, obviously, to financial sector, but it's also something that I thought I should highlight with respect to Telecom. We do not have that in Kenya. I've not seen it in Tanzania, and I've not seen it in some of the other jurisdictions that I've been involved in. But I've seen some Tanzanian lawyers, including Stella, in the webinar, so they'll be able to correct us if that position is not the case. Now, with respect to IP, so two things. Number one, when you're dealing with an asset sale, and I think that is really where the critical thing is, or even before I deal with that, I think the first aspect of an IP, particularly in an industry like telecoms, where IP is a significant asset and part of the business, normally is a due diligence. You need to undertake the due diligence to ascertain ownership or the right to use that IP. As John has mentioned, it could be third party's IP, in which case then you will require the consent of the third party holder who licensed it to the target or to the business that is being acquired or is being part of the transaction. That is number one. So once you're comfortable with the due diligence, if then you are dealing with an asset sale, you will then have to provide the general framework for acquisition in the asset sale agreement or asset purchase agreement. But in addition to that, as part of completion, you will then need a deed of assignment or a deed of transfer, which is a document that you will really end up filing at the registry, at the intellectual property registry in the relevant jurisdiction to signify the assignment or the change of ownership of that particular IP. So that will be the case in as far as an asset sale is concerned. Now, with respect to an acquisition of shares, for owned IP, that is IP that is owned by the target, you really wouldn't, there are no formalities, additional formalities that would be taken, apart from, of course, once you've done due diligence and you're comfortable with the ownership, number one, providing for warranties, giving you assurance or comfort that indeed that entity owns the IP, and of course for the certificate of registration and any other documents that represent ownership of that IP to be handed over to you. Now for leased IP or third-party IPs, you then need to, as John mentioned earlier, need to obtain the consent of the counterparty to allow you to continue as a new owner to continue using, or to allow the target to continue using that IP. But it's a critical aspect. It's something that obviously needs to be addressed all the way from due diligence confirming ownership to completion of the transaction. Now, on the COMESA, sorry.
No, please continue.
Yeah, okay. On the COMESA legal regime, so the thing is, Tanzania is not part of COMESA. Tanzania is part of SADC. So, and I think Stella actually mentioned that in the chat. So COMESA, the COMESA competition regulations and the whole COMESA competition regime will not be applicable to Tanzania. You will have to file a specific application to the Fair Competition Commission in Tanzania. Now, but I've also seen a question asking how exactly does COMESA work, or the COMESA legal regime? This is applicable, of course, to a transaction that cuts across the regional block, not the whole of it, but the way it is worded or provided, it's applicable where either the acquirer or the target has operations in at least 2 member states within COMESA. So if the target has operations in Kenya and Uganda and Rwanda, or just in Kenya and Uganda, then that transaction, chances are that transaction is notifiable, subject to meeting the various applicable threshold, because they are applicable threshold. And operation is not just by having a subsidiary, it's a term of art. You will have to have assets or turnover in that particular jurisdiction of at least $5 million equivalent. So that's the first test you need to carry out. Now, you then need to carry out other tests, including confirming what is the combined turnover or assets of the merging entities. It has to be above $50 million combined. In addition to a lot more other tests that probably I do not need to go into at this moment, otherwise I'll lose to. But the message is, whenever you are carrying out a transaction, which has either the acquirer or the target, with subsidiaries or operations in at least 2 member states within the entire 19 block members of COMESA, please carry out a COMESA merger analysis to then satisfy yourself that it's applicable or it is not applicable.
Wow, David, thank you for that. And actually, there was a question for you looking at maybe this is JB's in regards to the taxes. Do telecoms in other countries of the East African community face the challenge of higher taxes and penalties? And what about the effectiveness of interoperability, especially in money transfer between many telecom companies? Really, either of you could answer this, David or JB?
I think from a tax regime point of view, telco space is considered as, the new cash cow, and heavily taxed all over the region. So it's not any different in Uganda. When you look at, let's say, $1 earned by a a telco, you'll have at least basic tax components going as high as 40%, even before you look at the corporate tax regime. But simply, you know, what is tax? You have VAT, excise duty, and all manner of other charges. So across the region, taxes are high, and also there are other forms of direct taxes or fees that are paid as levies, so to speak, all purely applied on the different products in the telco space. So it seems to be that the community members are looking at each other on how these taxes are applied and trying to take a share of the money before they look at the final declarations by these entities. So it's not only Burundi, although I think Burundi, as compared to the region, is somewhat a bit on the higher side. If you look at the comparative scale.
Actually, JB, since we are talking about this aspect of, actually, this is now the second question, the aspect of interoperability. I wanted you just to share your experience in regards to forming the first star company in Uganda under that sell and lease back model. But before that, just for the audience to be able to understand, what is the difference when we talk about a tower company and a telecommunications entity? You could try to relate that to this aspect of interoperability. As we know, for example, in Uganda, that aspect of interoperability is one that is regulated under our law. David can confirm if that's the same in Kenya, but JB, you can also be able to give your experience from Tanzania and Burundi, but I'm sure this is still the same across the region. So if you could please just kindly break down for us, what is the difference between a telecom company and a tower company, but specifically, and then after that, we can then be able to move to the next part of the question, which is around the sell and lease back model.
Yeah, thank you. I think there are two things that we need to look at. One is interoperability. The other is what is technically called number portability. Interoperability is what came out between the value-added services segment, especially when mobile money services were introduced, that you should be able to seamlessly work with all the networks across, then that you are connected and you are able to send money across. But then there is what you call number portability, that you can be able to move with your number to any network. For example, you have your mobile number XXY, but you can at any one point change service provider with that same number without having to change a number. So that is something that has been a point of discussion for a long time in the region, and it's never been fully implemented. It was tried on multiple occasions, but there are various challenges with it, and no one has come out to say fully that this can be implemented. But for interoperability in the mobile money space, that has worked well, and different regulations in the region have provided for it. So you can easily send your money directly from any of these operators to the other across the borders. MTN to M-Pesa to Tigo and things like that. So that is already applicable. Now, going to move that model into the towerco space. So as you all may know that the operation of the running and operation of towers is not necessarily the core business of a telco, but these are what you call passive elements that enable you to get into the to provide the telco service. you need these as the basically the back end services. So with those be taking a toll on very many telecom operators, then came out a strategy to strip out those passive assets because they could be operated as an independent unit. And we saw many companies coming up to specialize in that space to basically be the agents of these telcos to operate these passive assets and let the telcos concentrate on their core businesses. So that is when companies like, ATC came about, American Tower Corporation. We have Paradigm, we have Minara now in Tanzania. ATC is already in Kenya as well. In Rwanda, we have IHS. I advised on IHS entry into Rwanda. So it was now the new way of being effective. And when we were looking at setting up the TowerCo in Uganda, because the towers were coming from one single operator going to a new entity, we looked at having to sell these towers and then lease them back, because you continue to stay on the tower as an anchor tenant or as a tenant while you have sold it, basically. So you sell it, you get capital out of it, and then you remain as a tenant and pay rent on it. So many a time you enter into long-term agreements because this buyer of this tower has got to recover their capital investment that they have given you. So you will end up into a long-term agreement for you to be hosted on that. And you will guarantee that you will be the anchor tenant and you will therefore never leave, because the moment you exit that, then they will lose out on their recovery process. So quite often we also see that you will have to get a most favored nation right over the towers. For example, that you have some preferences as the anchor tenant. So in exchange for you being the anchor tenant, then you get some most favored nation rights over other future tenants that come onto the same tower. So, and in that process, you must be careful to ensure that both the sale and lease are treated as arm's length transactions, that then you do not breach any competition regulations. So you must have seen, Kenneth, that decision by the UCC in regard to the Eton or rather ATC Airtel engagement with Ubuntu in play. So those are some of the considerations that you have to look at, but this is driven by the fact that many entities came out to try and operate in a lean manner and take off some of the dead wood in order to concentrate on their core businesses.
David, is there anything you'd like to add there specifically around that aspect of interoperability? Do you feel that this the model of delinking these entities to create the tower companies, is that something that has worked in your experience, or is that, do you feel has that allowed these companies to collaborate and discuss more? Has that allowed them, as JB has mentioned, to be able to concentrate on their core businesses and allow the tower companies to run these assets independently? Is there anything you'd like to add there?
Yeah, can you make me spoil it? I mean, I think John has conclusively address that question, and I agree with him 100%. I mean, that is the same model that is applicable that we see here. None of the leading MNOs hold the towers, and they seem to be working because, in fact, it brings efficiency and allows one tower operator to host a couple of players, and I think that can only be a good thing for business. But otherwise, let me not say more. I think John has really exhaustively addressed the issue.
Okay, so maybe we can then move a little bit to the field of technology. If we're looking at that aspect of these entities talking to each other, collaborating to each other, and in many systems as well, being able to utilize and connect and interconnect amongst themselves. This, we're seeing more telecom companies employ open APIs, that's application program interfaces, to allow them to be able to connect to their software or to their platform, especially like through mobile money. Do you think this is something that's likely to continue to grow as these companies expand and perhaps even get out of traditional telecom practice, perhaps into the field of technology? In Uganda, for example, I don't know whether JB you saw this, but there's an article recently that was looking at MTN in particular, venturing into the digital financial. Okay, well, they're already offering mobile money, but now they're looking at offering other technological solutions to entities, and this will be another arm or aspect of their business. So do we see telecom companies really moving away from traditional telecom practice, David, to now, moving into things like pushing further this interconnection thing and being more technology companies rather than telecom companies?
Yeah, I think so. And obviously, I welcome John to give some more perspective on this. Is really the insider. But given the competition and the fact that voice, mobile money, and some of the other traditional areas the telecoms have been playing in as sort of, I'm trying not to use the word saturated, but it's sort of almost reaching its limit. It really is putting a lot of pressure on them to try and explore other areas and other streams of revenue. That is really what is informing the move to these other new areas. But I think, John, probably being the insider, you are better placed again to take that.
John, is there anything you'd like to share there?
Yeah, I think we have seen what we call value-added services, or VAS in short. This is that a telco is going beyond what used to be the traditional voice and connectivity. I need to be able to give you more than just that. And this is all aimed at driving the businesses and increasing my wallet share from the consumer. Because I know you use your banking platforms, I know you read your news, I know you do so many other things. I know you watch your soccer online and things like that. So how do I capture a share of that spend, basically? So all these innovations are driven by the need to increase my wallet share from the customer. You end up focusing on more out of the norm services, so to speak, because as David has pointed out, everyone provides voice connectivity. Everyone provides data. So what makes you different? You will end up having to innovate and move beyond those traditional services. This is why you end up having to create more specific entities that are running the innovation business as opposed to the traditional services. I'll give you an example. At Telecom, we do offer connectivity and ISP internet. But on top of that, we then realized that you cannot just offer the internet. So you bundle it up with security, internet security. that I am giving you internet that is secured, and you should not look for someone else to give you security for the services that I am already providing to you. So we see that, you know, you end up having to innovate and offer more than the basic service that you are going into. So when you see what they are calling the Internet of Things, that's where you are going. And if you look at now, the global trend is for entities to transform just beyond providing the traditional services.
Actually, JB, since you're already talking about technology, thank you. I think we've looked at how, you know, most MNOs are now looking into open APIs and allowing entities to be able to connect with them at that scale. But in incorporating many of these technologies within the telecommunication sector, things like artificial intelligence, we know for many of you who are listening or watching, we have, you know, I don't know whether you've interfaced, for example, with ChatGPT or ChatGPT, which is an artificial intelligence tool that has really, you know, put many of us on pressure, seeing how artificial intelligence has really morphed into something that now we are trying to apply every day. We know that we already use this with other search engines like Google and the rest, but the manner in which it is used, in the way that it is now more specific. Now, do you feel, JB, that AI, you know, are we seeing more application of these technologies within the telecommunication space? Do you also see any challenges regarding regulation when it comes to things like artificial intelligence or IoT and the like?
First of all, from maybe a historical perspective, a typical telecom company had what they called a business intelligence department. So that BI department is what was in charge of, you know, data analytics, market surveillance, and things like that, which is now simply transforming into what you are seeing as AI in that space. So it's still an improved version of these business intelligence departments, and they use, while that task was performed by individuals, now they have gone on to be innovative, that you now have apps designed specifically to do these roles. You know, we had the big data analysis, product designs, consumer behavior reviews, and even as far as pricing. So basically you have a system where you just put in a few things and it gives you what your price should be to the final customer. And also how to design your network, you know, looking at fault detection, quality of service, and also the basic customer care services. Now they are performed by, you know, virtual assistants, chatbots. You know, some of you know that you can interact with a chatbot to get assistance when you are doing some of these transactions. And that generally leads into cost savings and more process automations. So AI now is simply considered as advanced business intelligence, and it is just helping telcos reach these decisions much faster. Now, as it grows in its application, of course, in will come so many challenges, especially when it is either regulated, unregulated, or semi-regulated, because it's a developing technology, and it seems to develop much faster than the regulation can. But now the question that we seem to be faced with is, first of all, how do we define AI? You know, you can't, basic things like machine learning, you know, even your spreadsheets and statistical methods are all now being done as AI. So should we say that, you know, you getting a spreadsheet and entering some basic formula and leading out to an automatic result, does that qualify as AI? Or should we only restrict it to the ability of machines to perform tasks that would ordinarily require human intelligence? So it becomes a blurred line as to where should we stop in terms of deriving the definition. But also the other challenge is driving into the data privacy realm, because AI is purely data input. It's a set of you know, algorithms that are defined, and you feed them with data, then they will give you the output. So you are looking at, you know, things like there's AI that they say, I think in New York it was choosing more white people than black people for kidney transplants, simply because someone coded it that way. So, and you know, the challenges grow as the more advanced the technology becomes. And then you'll have also your typical jurisdiction question. Is it global or local? I mean, you are buying your Tesla from the US, a self-driving Tesla in the US, and driving it in Nairobi. What are you going to look at? We now have also, you've seen how increased these loan apps have become. You know, you can be able to borrow money from anywhere on a loan app now. You just have to put in a few things here and there. Now the question becomes, where do I regulate that? Is it from the developing country, or from the user location, or from where, let's say, the owner is based, and things like that. As well, we have the liability question that will arise. Is it the user, is it the developer, or is it the vendor of the AI? You know, it's user X doing Y that is resulting into liability. So, but they are using a system that is not theirs. They simply have a license. So who do you hold liable if ChatGPT gave you a wrong answer and you relied on that to actually carry out something that resulted into liability? So, and also the basic thing is it's a moving target, because this technology is growing, and we can't just future-proof it the way it is. As it stands, it started from basic things, and now we are more or less into bigger advanced stages. So the law will have to also keep changing as the innovation grows in that realm. So with that, you find that you cannot do static legislation that you will say is in place. I mean, we've seen this with the European Union. They tried to do legislation, but the more they are legislating, the more the systems advance, and things become a lot more and more complicated, that the laws become inapplicable anymore, because every other year there is advancement. We are talking now AI representing litigants. You know, you've seen robots now, robot lawyers in place. So, but is, for example, the legal framework regulating lawyers already amended to look at robots as representing litigants? Not yet. So the future is uncertain, and that is why it becomes very hard for you to legislate.
Oh, thank you for that, JB. And actually, maybe perhaps I'll just answer William's question before I ask David another one. William was asking how the emergence of new technologies such as 5G, IoT, have impacted M&A activity in the telecom industry and legal challenges that have arisen as a result. So, William, as JB really has explained, many of these technologies are now being applied in all these sectors, including the telecom space. And if you're looking at technology like IoT, if you're looking at M&A, then if it's a merger, the company that is being acquired, those systems that they're employing to be able to carry out all these functions have to be considered in the documentation of paperwork when it comes to that, to one company merging with another, in the sense that which systems, for example, are more are a better a better use case. Even if it's a dominant company acquiring another entity, you'd find that the entity that they're acquiring perhaps has better technology in a particular space. And we've seen that now there is a more targeted approach with these companies looking at working with other entities that are adding value in regards to the sectors where perhaps they may not have the same expertise or the same impact that a company that has focused specifically on that is doing. We're moving more towards a niche industry where we have specialization, not only in telecoms, but even in the other sectors as well. So I feel even in regards to acquisition, this is something both panelists have spoken about in regards to catering for the intellectual property, being able to determine that if you're purchasing software from a company that has been acquired, how is this software going to work within my entity? How am I going to handle the data transfer? And actually, even what we're looking at asset stripping, data protection, as JB has introduced, is something that I feel is very key whenever you're looking at mergers and acquisitions. Not only at that particular level where you're buying a business as a going concern, but even for businesses that are exiting. I know that in Uganda, for example, now these entities speak to each other, that we have a data protection authority, and before anyone exits, you must be able to confirm or affirm to our Uganda Communications Commission that you have complied with data protection laws before you can exit the market. And actually, maybe this is now the question that I wanted David to be able to look at. With your experience with cross-border mergers and acquisitions, are the laws conducive in this particular space? But even then, outside of that, is that issue of the cross-border transfer of data something that we should be looking at? Are there any restrictions in the law, to do with the cross-border transfer of data? But specifically, it can just speak to the experience with cross-border mergers and acquisitions.
Thank you, Ken. So obviously, data protection in a number of the jurisdictions is a fairly new area it's a fairly new legal framework. And we've started seeing in some of the jurisdictions, at least we've seen in Kenya so far, some actions from administrative action taken by the Data Protection Commissioner against certain businesses for alleged infringement or non-compliance with the data protection law. We've also seen certain people going to court for alleged breach of their personal data, contrary to the data protection law or the various instruments under that. So it's an area that is really developing, and no doubt we will continue seeing a lot more of it being manifested in transactions. Having said that, so far, I think you look at it from different perspectives, particularly with respect to M&A. Now, a due diligence, as a purchaser or as an interested person, you definitely would require access to data. And when you are dealing with a telecom player, that data could involve different data subjects or information relating to different parties. You would then require comfort, or the target itself would need to be certain that it is able to release or to make available this data to the purchaser or the interested counterparty that needs to look into this information for purposes of evaluating the transaction or determining the way forward. The good thing is, in some of the policies that are being developed and the data protection laws, the various data protection laws, do anticipate, or some of them do provide for mechanism, while of course your data is protected and must not be shared with an unauthorized persons. There is a carve-out, or a carve-out could be included in those data protection policies or the terms and conditions, because typically most of the contracts that are entered into with these telcos or other entities are really more of in terms of terms and conditions that you just accept by clicking a button. But they also do have what I believe are binding provisions relating to data protection. So they even provide a cover which says, in the context, if we undergo a reorganization, or if we undergo a sale or an acquisition, or we are in the process of doing that, then we would be able, or we should be able, under that data protection policy, to provide relevant information to the interested person for purposes of ascertaining and structuring the transaction and even implementing it. Obviously, that does not extend to what one may call highly sensitive data or personal information, things like religion or race and the like. There are quite a number of them that are set out in the data protection law, but at least to the extent that it enables or allows the parties to transact, then that would provide a framework for the conduct of due diligence and the implementation of the transaction. So that is the first one, due diligence. Now, when it comes to implementation of the transaction, we have started seeing, and I don't think it is properly developed yet. I think it's something that can only continue growing. Warranties and protection provisions relating to data compliance with data protection laws, okay? Now, the default position that you tend to get when you're negotiating with the other side is, look, you're asking me to warrant or to give you comfort that I'm compliant with the data protection law, but are you able to tell me how many corporate entities in Kenya, for example, or in any other jurisdiction are compliant with a law that is only 2 years or 3 years old or a couple of months old? I'm not. And you see, the moment you give a warranty, it's not something you are just giving for granted. It's potentially a liability to you. So the moment someone, a couple of months or years down the line, hit by a regulatory sanction for non-compliance, that could come back to you because you gave certain comfort in the acquisition agreement. So the default position we've been getting is, no, I'm not able to give you this warranty. What I'm able to give you probably is, well, I've started developing a policy. I comply with the contractual arrangement I have with my subjects. But in terms of the data protection law itself, that has not yet been fully developed. That said, we've seen a couple of them in transactions, both in terms of indemnities and warranties. I think going forward, as we continue getting a lot more understanding, not only of the data protection law, but also of the seriousness of the regulators to implement the data protection sanctions and to sanctions businesses, this is likely to be a significant area that we are going, M&A practitioners are going to pay and to give necessary attention to.
Oh, David, very well said. I think perhaps maybe something I can also add there, whenever you're dealing with a cross-border transfer of data, we look at what we call standard contractual clauses. These are agreements that allow the safe transfer of data across jurisdictions. And if you're looking at mergers and acquisitions across borders, usually you'll find that for a merger which is, for example, in Tanzania, and I am the lawyer in Uganda that is looking at that, you'll have data rooms or rooms where you're able to get in and review documents. And I feel that, as a legal practitioners, it's important to be able to have clear policies that guide, how is that data going to move across those jurisdictions, because of course technology makes it easier. You sit in your office and you think that someone is just right next door, but this is someone in another country. And if you have sensitive data, or if you have all these categories of data that we're talking about, it's important to be able to review all these in a safe manner. And that's how those data sharing agreements come in and those standard contractual clauses that determine exactly what each of the entities needs to look out for as data is transferred. So overall, I think the insistence of preparation of policies, even during mergers and acquisition transactions, is something that lawyers need to look out for. And David, since we are looking at that, are there any other tips you can give to lawyers when negotiating, drafting, or reviewing mergers and acquisition transactions? Anything, if you have a checklist, for example, can you just tell us, okay, look at this, look at this, look at this, and JB, that question will also come to you as well, just to be able to supplement.
Yeah, absolutely, and thank you for that, Ken. So I think the first one, and because in this market, and by this market I mean the legal region market for M&A, we do not yet have the luxury of detailed specialization the way it is out there in some of the jurisdictions that, should I use the word, a lot more advanced, or at least have that level of specialization. So you'll find a lawyer who handles M&A in telecoms, will also do that in finance sector, in agribusiness, in FMCG, and so on and so forth. So the starting point typically for me is, number one, you need to really understand what the parties want. What is the commercial deal? That is the first thing. Second thing is, if, say, of course, I'm investing in an entity that holds a content service provider license, I need to understand to what extent, what exactly does this business deal with? So the second thing I would quickly mention is understand the sector. So with respect to telecoms specifically, it would be good for you to take some time to try and understand as much as possible and read through the principal telecommunications laws and the regulations under it. There are quite a number of regulations in this sector. And the reason why that is important is you may encounter a number of issues that are relevant to your transaction, both in terms of what approvals will be required and the timelines that are required for you to obtain the approval. But apart from that, you then would need to understand what license specifically is this entity supposed to hold. This entity is supposed to hold a content service provider license from the telecommunications authority or regulator. Do they hold it? A due diligence, that's a relevant question that you need to address. Are they complied with the various terms and conditions that are specified either by regulation with respect to that license, or that are in fact specifically set out or provided by the regulator with respect to that license? Do they do annual reporting and filing of returns and payment of regular annual renewal fees to the regulator? Things like those are things that you must need to address. And something that is also very important in this sector is what we call local law shareholding requirements. If, say, and I know quite a number of them do have, certainly Kenya, we do have a local law shareholding across all the sectors. I believe some of the other countries do have. Tanzania certainly have encountered that. So you need to be able to understand that, so that if your client wanted to acquire, say, 100% of the business, it will be important for them to understand from the outset that that, in fact, is not possible. And the question then would be, how would it affect the transaction? Would it result in the transaction being abandoned, or should we structure the transaction a different way? If, say, we were then to attempt to structure the transaction, do the local shareholders or local partners have the appropriate capital to be able to match whatever amount of capital they are supposed, or they will be required to contribute in order for them to acquire, or at least in order for the parties to attain and comply with that local law shareholding requirement. If you miss that, you may end up complicating the transaction for you and to your client, and you may end up frustrating or delaying the transaction significantly. If, say, you do not understand how long it will take to obtain the consent of the regulator, maybe it takes 30 days by law, or 60 days, and you had not factored that in your transaction, that may be a significant gating issue that would then impact the transaction. Now, the second aspect that I needed to quickly mention is on due diligence. And the aspect of due diligence is important. It's actually connected to some of the things that I've just mentioned, but it's really important because that's what really helps one in identifying risk. And once you identify risk, if you address all the issue of licensing, compliance with licensing requirements, compliance with local law shareholding requirement, and then you move on to drafting and negotiating the transaction, you will then need to understand or figure out how to manage or allocate the risks. Should we manage these risks by way of putting a condition precedent to the transaction that the consent of the regulator need to be obtained, the consent of the counterparty with respect to IP, for example, need to be obtained. If the target did not have a license or did not comply with a specific term, is it that material that it may cause the company license to be withdrawn, to be cancelled by the regulator, or is this something that hopefully with time the risk will disappear? And if that is the case, how do we manage that? Should we have an indemnity to deal with the possible repercussion of that? If there is something that needs to be rectified, should we then be talking of reducing the purchase price and things like that? So once you identify the risk, that's when then you'll be able to figure out how to manage and how to allocate between the purchaser, the seller, and any other party to the transaction. Then quickly, Ken, let me just mention this before then John comes in. So in terms then of the actual implementation of the transaction, it is really important, and this is connected to what I mentioned earlier, understanding the commercial deal, for you to be very clear on what the objective of the parties are. That's number one. And how flexible your client is on some of the issues. What are the possible showstoppers? Are there things that would completely not work for your client, and accordingly, this need to be flagged from the outset, either for the parties to discuss at a commercial level, or for the parties then to agree on different mechanism of structuring the transaction. I think I can pause there, Ken.
David, thank you. JB, I don't know whether there's something you'd like to add, but also there's a question maybe so that you can be able to merge the two. Sheila Marandu is asking, in the acquisition of a telecom tower, what common challenges or hurdles can lawyers avoid so as to reach a smooth closing or transfer?
Thank you, Ken. I think David has more or less listed the core things. Please, as a lawyer, understand what is the deal that the parties want, do due diligence, and then structure the transaction based on, what are the results of that due diligence and in line with the deal that the clients want. And always ensure that you have less conditions both precedent and subsequent, because those are what fails the deal. So don't put so many gates in your deal, otherwise it may never pass some of them. And ensure that you have obtained all the relevant consents from regulators, from lenders, from shareholders, etc. So that's more of the basic tick boxes that we need to look at. Now, in between those, you'll find very many detailed things depending on the nature of the M&A that you are dealing with. Now, in relation to the tower core space, that's to the question from who asked the question?
It was Michelle, if you can go to the answered part, just the last question there.
Yes. So in terms of what are the pit stops to closing these TowerCo transactions, it's always the third parties because a lot of this infrastructure is seated on third-party players. You know, you are looking at like the landlords who host those towers. You are looking at regulators, for example, when they are considering whether you are create the result, the transaction will result into a monopoly, and you are also looking at valuations. Quite often valuations fail deals in the TowerCo space because, you know, I'm looking at buying your tower that you built 10 years ago, valuing it at present value, and you seem not to agree because for you are generating a lot more money from it, even if you built it over 10 years ago, whereas I take present valuation, then the figures do not add up. So some of those things need to be checked out well beforehand. The other thing is when those disposals are happening, you have a lot more issues to do with, you know, minority shareholders and whether they are well catered for in respect of the results of the disposal or the acquisition, whichever it is. So you find you have to ensure that you are watertight in those elements. But like I said, less is more, because then you have chances of succeeding at completing your transaction. If you identified certain elements during DD phase, please have the responsible parties try to clear them before you sign the actual deal, instead of saying, oh, I will try and build in a protection against that, because that protection may not hold when it comes to closing the transaction.
JB, thank you. David, I think we're actually coming to the close of our webinar. So I'll ask the last question to David, and then I hope there'll be, if there's anyone who'd like to contribute, please do let me know, and I can be able to unmute you and you can be able to share whatever you have to share. But David, there's a question in the Q&A from Sloan Onderi on the conflict of roles between the ESC Competition Authority and COMESA Competition Authority. Is that, could you please answer that for us?
Yeah, okay, thank you, Ken. So now, Sloan, to my knowledge, the ESC competition regime or framework has not been fully operationalized. I know they do have a secretariat based in Arusha, Tanzania. They are probably trying to put together the institutional framework. The legal framework is there, but the institutional framework has not really been actualized. And as a result, to my knowledge, I am not aware of any transaction that has been submitted to that competition regulator yet. We try to get more information from the Competition Authority of Kenya on the interplay between the various regulators and the duplicity, and of course the challenges it brings to businesses. And at that point, when we made that inquiry last, the position we were given is, look, it's not yet operational. You do not need to concern yourself with that. You just should concentrate on the municipal competition law. That said, the framework is there, the legal framework is there, the COMESA competition framework is there. The thing is, with respect to the COMESA competition, once you do your analysis and you're satisfied that it is the transaction is subject to the COMESA Competition Commission, you would be required to do a filing. And in fact, you need to do that notification within 30 days. Otherwise, your transaction would be affected. It could end up being void, although they have a cure mechanism. Okay. Now, the COMESA competition regime is supposed to be a one-stop shop. But the unfortunate thing is for some of the member states, you would still be required to do some sort of a filing, much as it's not required under that regime. We had that tussle between COMESA and Kenya, but that has now been resolved the last couple of years, so it's good. But for some of the member states, you still be required to file. Assuming the EAC is the EAC institutional framework is implemented in the near future or becomes actualized, then we will need to figure out, is COMESA still a one-stop shop? One will need to carry out that analysis, or will be required to file in both of them. I won't be surprised if in the initial stages, until they sign some sort of memorandum of understanding, as they do sometimes, we may be forced to do a dual filing.
David, thank you very much. I think, Sloan, I think that answers question. Lucy is asking, what are some key terminologies used in M&A that we should be familiar with? Lucy, this is something we've been speaking about, I think, the entire webinar. We've learned about things like sell and leaseback model, and JB explained what that is. David gave us a rundown as to what a merger is and what an acquisition is. Maybe if the two of you, as we sum up, can just try and summarize. Are there any other terms maybe that you can just throw so that you can that Lucy can know what other terminologies we can be looking at? David first, since you just spoke.
Yeah, thank you, Ken. I think what I can do, probably I can just quickly mention what I would consider, although this is really not cast in stone. We are all lawyers and we are all have our own free mind and able to apply our thoughts accordingly. It's just what one may call the framework of an acquisition agreement. And an acquisition agreement could be anything, as John explained earlier, because there could be so many acquisition structures. So it could be a share purchase agreement. It could, in fact, be an investment agreement, and it could as well be a subscription agreement. Those are just some of the ones that are applicable. There are so many. A convertible instrument could also amount to an acquisition agreement, depending, of course, on whether the conversion happens at the end of the day or not. But just a quick layout or what I would consider is a framework is what one may call operational clauses, and then monitoring clauses or implementation clauses, and then lastly boilerplates clauses. Now, on the operational clauses, I'll be looking at things like a description of the commercial deal. What am I acquiring at how much? What shares am I acquiring at what consideration? Okay, that really is as simple as it can be. What would then need to be done in relation to that? Maybe some waivers, a provision for either waivers of preemption rights or right of first refusal, or any other restrictions that could be applicable to that is also put in there. Now, when it comes to, and that also includes the condition precedent clause, which typically follows that as an operational clause, because you then need to be able to move from agreeing to make the acquisition to completing, to in fact completing the acquisition. You need to address that gap that arises between signing and completion. And that gap really is a fulfillment of conditions. We mentioned quite a number of them in the course of our discussion. It could be regulatory approval. It could be third-party, counterparty approval, including, of course, your landlords, your IP lessors. It could be something to do with employees in the event of an asset acquisition. And I've just remembered, Ken, that we probably have not addressed that issue of employees fully, but it's something that obviously is relevant and one should always be able to pay attention to, particularly with respect to an asset deal. It may not necessarily be much of a big issue for a share deal, but it's relevant, certainly relevant for an asset deal, trade unions and the like. Anyway, that is it for operation. Now, for the monitoring, you'll then be dealing with things like the covenants that you get in that particular acquisition, the protections that you get, be it indemnities or warranties. And I don't know whether probably I should mention quickly the difference between the two. Warranties really is an assurance of or an expression of the state of affairs of a business. You're saying the business is good. You're saying the business is in order in terms of licensing, in terms of ownership, employees, land rights, and so on and so forth. Then you go to indemnities. Indemnities basically addresses a liability that has been identified. So you're saying, well, it so happens that there is a big litigation that is pending at the High Court in Kampala. We think that is going to be decided in our favor. If, however, it is decided against us, then we will indemnify you. Those kind of things. Obviously, there is a standard tax indemnity, typically not easy to negotiate when acting for the seller. The chances are you may just have to give it, but those are some of the monitoring issues that needs to be built into the transaction. Of course, then you have the boilerplate that addresses key issues. One may think that they are useless, but it's really, really important. And I think it's a mistake that we as practitioners, particularly the senior practitioners, make of not even going through it, but it's really critical. The confidentiality, the public announcement, the notices, the governing law, and in fact, that is really, really important. Governing law, choice of dispute resolution mechanism. Do I need to talk to my dispute resolution colleague to see whether we are going with Nairobi International Arbitration Center or Kigali International Arbitration Center, and so on and so forth, and why? Which one is neutral? Which one is beneficial for the parties? So some of those things that are boilerplates should not be overlooked. And lastly, which is part of the monitoring, is you then have your warranty schedule. It could be anything between 10 to 30 pages or more, depending, of course, on your deal. The message that I would give is, please try to customize your warranties. It is really important. Let's not deal with a telecom acquisition and you have a licensing warranty relating to banking or relating to agribusiness and the like. Some of them are generic in nature, granted, but it is in the interest of everyone to try as much as possible to customize the warranties as much as possible. And then, of course, in negotiation, one of the things that you should always bear in mind is it's a give and take. So sometimes you may have, without necessarily compromising your client's position, and while always deferring the commercial issues to your client, it shouldn't hurt so much if you want to facilitate a deal by ceding something to your colleague on the other side, or by agreeing to a different suggestion that may not necessarily give your client the best protection, but it facilitates completion of a deal. I think I'll pause there, Ken.
Thank you, David. John?
Pretty much, I think David has run through what really is the core content of a typical M&A agreement. But all those are always tailored towards what choice of structure you took, and or the how to do the transaction, or in this case, how to skin the cat, so to speak. So you will hear different phrases and jargons depending on what model is chosen in terms of how to do the deal. But the concept remains the same. You will have a deal, you'll have a deal structure, you'll have conditions, you will have closing, you will have indemnities, you will have warranties. So those basic elements cut across, but the specific, concepts and words and all that is based on what type of way you have chosen to do the transaction.
Thank you very much, JB. I think maybe I can add, since it's something we've been talking about as well, data protection. I'm not even sure if it would fall under the boilerplate, under the boilerplate sections, but now that clause on data protection and intellectual property are some that are key whenever we're looking at such agreements. And so those are some of the other terms that we can also be able to look at in that. I think really we've covered lots of topics, guys. David and JB, wow, this has been such a good panel. We've looked at the differences between a tech company and a telecommunications company. We've looked at the legal aspects regarding interoperability. We've looked at what a merger is, what an acquisition is, what the laws are across the region around those. We have been given tips, dear listeners, people watching, around what, as lawyers, we should look out for when we're negotiating, drafting, and reviewing these transactions. We have looked at cross-border mergers and acquisitions. We have looked at different modes through which these M&As occur. We've looked at tower companies and things like sale and leaseback in regards to that. We've also looked at aspects of technology, like artificial intelligence and the Internet of Things, how those play a role when we're looking at mergers and acquisitions, but also generally as trends within the telecom sector. So I think really we've come to the end of our webinar. I'd really just like to thank JB and David. It was a pleasure having you on today. For Julia and Sharon, we have missed you. We hope that you'll be able to join us perhaps on the other panels. This is a series. We had already a panel before this one where we looked actually at what JB had mentioned, that anti-competition, in particular, looking at ATC, Airtel, and Eton, and Ubuntu Towers. So we had the legal manager for Ubuntu Towers come to speak to us and give us an insight into what happened in that case that they filed before the UCC tribunal. But this is really just to thank you all. The next webinar will be at the end of April, and where now we'll be going into the field of technology in particular. I think, no, actually, this will be the field of intellectual property. I think we'll be looking at sports law. I'm just trying to get the topics that we can have, so you can have clarity. We'll be looking at infringement in the media and sports industry. So we'll be looking at notice and takedown. For those of you that are aware of that case, MultiChoice Kenya and versus Safaricom and Jamil Telecom, in regards to takedown. How does an ISP have to respond whenever you receive a notice and takedown for an intellectual property infringement claim? This is something we'll look at, and thereafter we shall also be looking at other emerging technologies, opportunities, and threats for looking at contracts within that space. So we really have a lot of stuff that we're going to be looking at throughout the course of the year. I'd also really just like to thank East Africa Law Society for, of course, putting this together and hosting. And unless you have any parting shots, David and John Bosco, let me allow you to go back to your work as you finish the afternoon. And you've given us a lot of your time, and to thank you really from the bottom of our hearts for accepting to speak to us today.
Thank you, Ken. Always a pleasure.
Okay.
Thank you, Ken.
All right. Bye, everyone.
Goodbye.